You've been arrested and charged with a crime. It's all you can think about. It's affecting everything, including your job and your family. You're walking into court for a pretrial conference facing the district attorney who's trying to convict you. You need help, but don't think you can afford an experienced criminal defense attorney. That's where we come in. At Afford Law, we'll use our decades of experience to protect your rights without costing you a fortune. We'll guide you through this journey to come out safely on the other side. We'll fight for you so you can get back to your life. What is a pretrial in a criminal case? A pretrial conference, also called a pretrial hearing, is an extremely important step in the criminal justice process. It takes place after you've been arraigned and before a plea bargain or trial. During the pretrial stage, the government is building their case against you. They talk to your accuser, witnesses, and the police as they try to convict you of the crime. They have tremendous resources at their disposal. You're in for an uphill battle. The purpose of a pretrial conference is to bring the prosecutor and us together to discuss the case. This is the discovery phase. Discovery is very important because we need to know what the evidence the Commonwealth has that will be used against you. We need to see such things as witness statements, video surveillance, and forensic test results. In addition to receiving discovery, a criminal pretrial conference is where negotiations to resolve your case begin. Very often, the purpose of the pretrial conference is to end your case prior to trial. We will explore the possibility of getting an offer on your case that will not involve jail time. By meeting with the prosecutor before trial, we may come to an agreement that would be acceptable to you. Can you go to jail at a pretrial conference? Generally, you won't be sent to jail at a pretrial conference. As stated above, the purpose of a pretrial hearing is to receive discovery and negotiate a plea agreement if possible. There are circumstances that could land you in jail at this stage, however. Those circumstances happen outside of the pretrial conference setting. Reasons for ending up in jail at this phase include getting rearrested, violating your conditions of release, and having the bail returned to the surety. If somebody else posted bail for you, they are the surety. If they ask for their money back while your case is still open, you'll be taken into custody if you can't replace that bail money. What to say at a pretrial conference? You shouldn't say anything at a pretrial conference. Let us do the talking for you. This is true of every step in the criminal justice process. Anything you say can and will be used against you. The most innocent sounding statements can be twisted, creating more trouble for you. Remain silent. Who can attend a pretrial conference? Anyone can attend a pretrial conference. It's a public forum. Your accuser does not have to attend. They are not required to show up for anything except the trial and perhaps a motion hearing. They may be present if they choose to be, but they don't have to be. Merely because someone isn't at your pretrial hearing doesn't mean they're not interested in pursuing the case. The district attorney's office is in contact with them and will bring them in when necessary. The only people that need to be at your pretrial conference are you and the prosecutor. Can a case be dismissed at a pretrial conference? Cases can be dismissed at a pretrial hearing, but that's rare. A dismissal at this point is only at the prosecution's request. That means it's completely up to the government to make that decision. A judge cannot dismiss a case over the Commonwealth's objection. Your case can get dismissed further down the road, but that must be based on some issue of law. What happens after a pretrial conference? Several things can happen after a pretrial conference. Depending on where your case is in the criminal justice process, the next event can be one of the following: another pretrial hearing date, a motion hearing date, a compliance and election date, or a trial date. Further pretrial conferences. There are usually more than one pretrials in a criminal case. It's a process to get and request discovery and to negotiate with the prosecution. This will take a number of court dates to get everything we need. We have to make sure everything is in order before we can proceed. Your case might be appropriate for a motion. In a motion, we are requesting the court take a certain action. We file a written document and have an oral argument where we try to convince the judge to give us what we want. There are two basic types of motions: motions to suppress and motions to dismiss. Motion to suppress. In a motion to suppress, we're asking the court to rule that certain pieces of information cannot be introduced as evidence in your trial. Many criminal cases are won and lost on the outcome of a motion to suppress. Without critical pieces of information, the Commonwealth cannot prove their case against you. Such motions commonly seek to suppress items such as guns and drugs, statements such as damaging statements you made to the police, and identification, if your case involves an eyewitness identification. Motions to dismiss. Here we're asking the court to dismiss one or all of the charges against you. Hearings on motions to dismiss can be evidentiary, where live testimony is taken from witnesses, or they can be non-evidentiary. These types of hearings are called de benedetto or four corners hearings. In such a motion, we're saying that there is not sufficient probable cause in the police report for your case to proceed. A compliance and election date serves two purposes. First is compliance. Sometimes the Commonwealth doesn't have the discovery we're seeking. They need to get it from someone else. If appropriate, the court will order them to do so. At the next court date, they must comply with the court's order and provide it to us. If they don't, they face sanctions, such as not being able to use that information at the time of trial. Election. Here, we're deciding or electing whether to go to trial. It's time to decide if you want to plea out to your case or take it to trial. After the final pretrial conference, your case may be ready for trial. All discovery is complete. Any motions have been heard. All witnesses have been interviewed. If you don't want to plead, it's time to take your case to trial. It could be a jury trial where 6 people from the community decide your fate, or it could be a bench trial where the judge, sitting alone, decides. How long between pretrial and trial? The length of time between the final pretrial conference and your trial varies. It's mostly dependent on the court's schedule. Typically, it will be scheduled in 6 to 10 weeks. Other factors come into play as well, such as availability of witnesses. Even if your case is scheduled for trial on a certain day, doesn't mean that it will go forward that day. Many courts schedule several cases for trial on any one day. A court is limited to how many trials it can accommodate on that day. They have to prioritize by certain criteria, such as if someone is in custody, the age of the case, witness availability, and the severity of the charges. A pretrial conference is an extremely important step in a Massachusetts criminal case. The purpose of pretrial hearing is to bring both sides together to exchange discovery and discuss your case. It's at this stage that many cases settle. Based on the facts, we may want to schedule a motion to suppress or dismiss. If those are successful, your criminal charges may be dropped. At Afford Law, we have experienced, affordable criminal lawyers ready to help you. Call us today for a free virtual consultation. At Afford Law, we're making justice affordable.